Thank you.
So let's see. Okay.
There you go.
So thanks and welcome to this presentation. For today, I have the great honor of introducing you to some topics related to customary international law and to the idea of custom. This is no doubt one of the most interesting topics in international law. And while preparing this, I wondered how to approach this, and I was a little bit concerned that maybe was I going too deep? Was I looking for too much information? So what I landed on was to just approach this as I have done when coaching teams. So right now, we're all having this beautiful discussion related to custom, and I'll try to keep it light as possible. This is not intended to be like this profound search for every bit of detail, but an introduction, so to help you understand the concept of custom, so that in your research for Jessup, you can know where to search and know what kind of information you should look for. The thing is, custom is one of the most complicated sources of international law, and is in fact one of the bases for what the International Court of Justice and international law usually means. You most probably are already familiar with Article 38 and with the idea that we have these sources of international law, which are the places or the points where we're looking for the contents of international law. But custom, in my argument, is indeed the basis for most of international law. Having said that, the presentation will consist of a part in which we will enter a discussion of legal philosophy and an approach to understanding what custom is, so that we can move to a second part where we can talk about the Article 38 elements and the way that the International Court of Justice has understood them. So let's start with Article 38 of the ICJ statute. In the terms of Article 38, we understand that custom is a general practice, a practice. Just 1 second, I think that the slide jumped. Let me see if I can, yeah. Okay, Article 38, we have this. The court was functioning to decide, in accordance with international law, such disputes as are submitted to it shall apply. And on the paragraph B, we have international custom as evidence of a general practice accepted by law. When talking about custom, we're talking about a very complicated concept, which from the outset, we usually understand in two parts. And most doctrine will tell you that there is an opinio juris and a state practice, and that these two elements combine. But in this first look at Article 38, we only have the idea that international custom is one thing. And it would seem that it's the evidence of a general practice accepted as law. So we're talking about the fact that there are rules that are created by custom, whatever that is, and that custom would be an evidence. Fact is, Article 38 wasn't intended to create a process to find custom, but rather to enable the court to actually study custom. But Pretel, what is custom? Well, to understand custom, we have to start first understanding the nature of international law. And for that, we're going to talk about some concepts. First of all, usually when we have the idea of a legal system, we tend to talk of these structures that either create the law, that exercise some sort of power to enforce the law, and some institutions that are created to observe the correct application of the law. We have your judicial, you have your executive, you have your legislative, and these three organs usually in states um, are in charge of the creation and the administration of the several steps that the legal process implies. Here we have an illustration that beautifully shows the elements of this classical conception of state and of legal system. And we have the legislative, the expression of the will of the people in the Liberty Cap. We have the sword of the executive, and we have the balance of the judicial. So in this idea, we have these organs, and we have a centralized power that expresses the will of the people and that creates law. Generally speaking, we have assemblies, we have legislative organs, and they create the law. And we have an executive that has a monopoly of power and forces compliance of the rules of law. And if there is a controversy, we have a judicial power that will strive to interpret the law so that we have this equilibrium. And that way, well, the society works and respects these structures that are created from the law. But the thing is, in international law, we don't have that privilege. The way that international law works, we have structures that are very different from the way in which traditional states actually consider this way of creating norms, of creating the order which corresponds to what is expected in the international society. So we have a process of creation of rules that responds more to the needs of a community and that is created by practice. To understand this, I have an example, which I like to call the playground example. When you're very young and you are in grade school, you have these playgrounds where you have a sandbox, you have your slides, you have your whatnot, and something's happened. Suddenly you are all alone, well, just as kids playing in the playground. There is no teacher to be seen, and yet there is an order in the playground. And there are some weird things happening, right? I mean, there are turns to use the slide, there are turns to use the swing set. There are people who actually obey these rules, which are not actually school rules, but which have been developed. I mean, kids will go and play soccer, and indeed, they follow the rules even in the absence of a referee. And we more or less know when the ball is out of bounds and when there is a foul and everything. And people still follow these rules. But I mean, football, that's a game that has rules. But in my school, in my grade school, there was this weird game that, as far as I know, is not played anywhere, which was played in the featured floor of the playground, which consisted of these giant panels of concrete. And those panels were used as a form of playing field. And each children stood on one of those blocks, and we bounced the ball, and there were rules as to how the ball bounced. And like, they were very site-specific rules to play this ball game. And as far as I know, and as far as any student from my school has known, there's no real origin to the rules. I mean, we have asked, and generations up know the game, but no one can be really sure where the game came from. And yet they were rules, and these rules were complied by mostly anyone playing the game. And so I wanted to understand how these rules could create something in the context of the playground. And I arrived to the conclusion of the fact that even if we didn't know the origin, there was a practice of this game that came from a long time ago. And that practice eventually became a rule set that we applied to play, even if no one was really sure of where it came from. And indeed, there was no referee to play this game, but everyone knew the rules, and there was a community enforcement of these rules. And indeed, international law happens that way. The international community is a huge playground where you have a lot of people playing, and sometimes someone may want to try to grab the ball and run, but indeed, the rest of the community, most of the time, will look to have a comprehensive enforcement of the rules. And that leads to my position regarding the system as anarchic. The system which we are describing right now corresponds more to these structures that lack a centralized control. International law sometimes is confused with the UN system, but indeed the UN system is not that with huge letters international law. The UN system is a framework for international law. And indeed, we have a huge universe of international law, which, it's true, has stemmed from the work of the United Nations. But most of the time, the system is anarchic. It doesn't correspond to a respect for a centralized power or a centralized executive. And if there is an international legislator, which we think that there is, it's diffuse. It's not actually an organ or even a concert of nations. But indeed, the system in which international law happens responds more to these structures in which community enforcement of the rules that are created by practice happens by the same community. Compliance comes not only from the use of power, but due to the consequences of international relations. And indeed, the anarchic position, right now I'm borrowing it from a bit of the theory of international relations. Like, in the absence of a centralized power, everyone is looking for their own interests. And what we call international law, what is created, are the common rules that serve to restrict the freedom of some states from interfering in the freedom of other states. In this vision of international law as anarchic, we see that the way that the creation of the norms happens is most of the time, at least in theory, egalitarian. The rules that are created by custom are rules that are to be applied to everyone, regardless of their position regarding to the creation of the rules. And we'll expound a little bit more on that on the next parts. But in fact, the norm creating process is a result of many factors and of many steps along the way. And most of the time, international rules are meant to be general and more or less objective as to their application. Indeed, in the international law studies, you can see that the central characteristic of international law is that most of the important norms are created indeed by practice, and we are to understand by custom. I ascribe to the idea that indeed the central theory of international law is custom. Our rules, as created, come from a long line of practice by states, testing the limits of what international law entails. And it's this practice that actually leads us to understanding which rules should be followed by the international community. And just as the playground example, the compliance with the rules is not subject to a centralized power. Indeed, states have a power of enforcement, but most of the times we think of this enforcement as maybe coming from the UN Security Council, for example. We're thinking about sanctions, and we're thinking about actions by the Security Council to force the enforcement of a rule of international law. But most of the time, the enforcement is subtle. It's not necessarily only from this kind of actions, and indeed is not centralized. For example, states can actually create measures, and they can be political or diplomatic or economic, that can force a state, no matter how big, no matter how powerful, to compliance with rules. And sometimes, due to reciprocity or due to other aspects of international relations, states will actually comply, and they will be led to compliance within the international community to these rules. So far, my position is that this system, though anarchic in essence, responds to an order of convenience for all the states. The rules that are created by the practice of the states are enforced by the community as a whole, and most of the time they respond to general requirements, to the desired conduct of each individual state in the collective. So, having said that, I think that we're ready to go to the formal contents of Article 38 and start talking a little bit about how the ICJ has approached the problem of international custom. So we go back to Article 38. And once again, the article says the court, whose function is to decide, in accordance with international law, such disputes as are submitted to it shall apply international custom as evidence of a general practice accepted as law. Well, that would seem, once again, that we're talking about just one thing. And it would seem, if we go back to the legislative history of Article 38, to the travaux préparatoires, that indeed there was no intention of actually creating this division of Article 38 into parts. What the committee that wrote the statute of the Permanent Court of International Justice intended, so far as we can understand from the available materials, is that there was this intention of enabling the courts to use custom as a way to ascertain the existence of rules of international law. And this is very interesting because custom, more traditionally, in some legal families, is a formal source of law. Like there are circumstances in which, for example, in the United Kingdom, in some of the Saxon traditions, the custom carry the weight, even in norms that were no longer part of this formal legislative process, but were lost in time. We had this very old rules, everyone accepted as valid. And there was this custom that was enforced by the courts and that was understood as valid. And in some aspects, nowadays, some Latin American countries, some African countries still maintain these structures of custom. But the practice has dissociated to the fact that in the modern world, lawyers no longer encounter these ideas of custom in their national systems as much as they used to, especially in the European countries, for example. But nonetheless, the idea is very straightforward. You have these norms that even if they're not written down, they're understood to be valid and they're understood to be legally compelling, an obligation, not a suggestion or anything. There are rules and there are legal rules and they have to be followed. And so these customary rules depend on a valoration by the judge of their existence. And in most of the cases, it would be just necessary to show that there is a practice and that the practice is followed, and that would be it. But in fact, in international law, the elements that bring us to the determination of a rule of custom are quite complex. We have to think that in many ways, custom is a sort of magic. And people like Alain Pelé have mentioned it as a kind of alchemy in the hands of the courts. And to think this, we have to accept the fact that law is a magical language and that legal relations are most of the time beginning with a word or with a phrase, and they bring into existence something more complex, sometimes in the real world, relations between states, obligations, protection for citizens. But it all starts with the word, and it all starts with ideas that are someone converted into being by using the language of law. So indeed, in positions such as the one held by Alain Pelé, the court, as a matter of fact, every time that it approaches the topic of custom, has to do a little bit of magic and has to ascertain the existence of a series of rules by analyzing them and by understanding that these relationships between states, that these external attitudes form an intelligible web of relations that can become a law. This compelling norm that actually changes the way in which matter is conducted. So the way that the court approaches this has a multitude of tools. And most of the time we return to understanding two elements, which we will expound in just a moment. But the thing is, the way that the court approaches this has more to do with art than science. We're not analyzing here a petri dish with bugs to see what they are. We're not actually analyzing the chemical composition of this or that to fully see if we have custom here. But in fact, several elements of the external attitude of states and of the way that they conduct their business in the international arena give us the evidence that we have a rule of custom. And the court is sometimes cryptic and sometimes a little bit vague on how they find this, because sometimes a norm of custom is just very suddenly stated by the court. The ACJ suddenly says, you know, we have elements to find out this is actually customary. But in fact, there is a process and there is a study behind. So it's not quite esoteric, but we have to be very flexible. And the ICJ indeed has like a huge latitude, a very wide margin of appreciation to understand what becomes a rule of custom. And we have to be very clear on the fact that the court is not interested in an academic discussion of whether something is a rule of custom or not. The court will study these rules in the context of conflict, in the context of the solution of a legal matter, in the context of judicial practice. So the way that the court approaches every analysis of customary rules has an intimate relation with the way that they're solving controversies. It would seem that by having these two elements that we have mentioned in custom, it would be just as easy to grab them and fill boxes, so to speak. And if the boxes are full, we have custom. But indeed, we have to look at a bunch of things when analyzing custom. We have to look at the relation with treaties. We have to look at the relation with general principles of law. We have to study the way that states engage in a meaningful way with these other rules to ascertain whether we actually have a rule of law or if we only have practice or opinion juris by itself. So so far, we have these elements, and just to close this part, the court indeed sometimes gives more weight to one of the factors than to the other, and sometimes it draws conclusion just having the practice of states, and sometimes it actually finds custom by analyzing the beliefs of the state, the subjective element. But indeed, both elements and both parts of what constitutes custom are always in play. And in the end, the analysis, the work of the court is taking all these elements and making something out of their existence. So, having said that, we should take a pause here to understand that custom is very much like a path, a trail that's created by the constant practice of states. In the words of Antonio Machado, caminante no hay camino, se hace camino al andar. Walker, there is no trail, the trail is made by walking. The trail of custom is indeed created by states repeating a conduct a lot of times. And every act that the entities of international law undertook from the ancient times has come to us in one way or another to create the rules of international law. We have rules that existed, for example, in the law of the sea, that started when men, for the first time, built a boat and took to the seas. When we found out the way to trade the production of our village with the nearby village, we started to create rules for trade. When a general arrived with a letter signed by the Emperor of Rome, visiting the king of a province, asking for specific favors in representation of Rome, and the king protected this emissary of Rome as a special guest on virtue of these documents signed by the emperor, which was called the diploma. Diplomatic law was being created, and all these rules that come from to us from antiquity and that are as old as humanity itself are creating international law. So indeed, the path of custom is a path thread a lot of time by a lot of factors with very different weights, and each in their own way affects the creation of general rules. So to start our analysis, we turn to the North Sea continental shelf cases solved by the ICJ in 1969, in which the elements of what custom is were spelled out by the court, and which is one of the first bases that you would be wise to read as a source for study of what custom is. And indeed, two elements are identified in this case. Reading the obiter from the case, two conditions must be fulfilled. Not only must the acts concerned amount to a settled practice, but they must also be such or be carried out in such a way as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. Indeed, the court is actually in its dictum starting to tell us that we have two elements. And this analysis, in which the way that the Article 38 mentions custom actually splits it in two parts, because what we're looking for is a practice that is an evidence of the existence of a rule. But the practice itself is the evidence that at some moment there was a belief that this practice was compulsory. So the court doesn't hesitate in actually splitting this into two elements, in which we first must understand that there is a practice by states. So not only must the acts concerned amount to a settled practice, let's dwell on this a little bit. We need a consistent practice by states. What is practice for the court in this sense? Well, practice are all those acts in which the states express their position related to an aspect of international law. What do we need right now? These are the footsteps on our imaginary trail. This is the evidence that the states are actually walking over this trail. Okay, so what can we look for? Well, first of all, administrative acts. And what do we understand by administrative acts? Well, any expression of the activity of the state that gives us element to understand that the state has a certain position will be a proof of state practice. It can be orders from an executive organ. It can be the positions stated in international organs by representatives of the state. It can be diplomatic communications amongst embassies of different states. It can be judicial activity, affirming certain practice based on international law. And in a more wide sense, treaties can be an important element to show evidence of state practice. How are treaties evidence of state practice? Well, the rules that states include in treaties are understood to be rules that bind only the state parties most of the time, and that the intention is to have this private recognition of a rule. Indeed, if we go back to Article 38 of the ICJ statute, you will see that the treaties, as mentioned in Article 38, to be considered as part of a resolution of a judicial conflict would be the treaties, whether general or particular, between the parties. And in fact, like in the first step, it is understood that treaties, most of the time, only create an obligation for the parties involved. But treaties can be used as evidence of the belief that there is a rule of law that is considered compulsory. And if this rule of custom is written down in a treaty and is being signed in a treaty by the parties, we could call this a process of crystallization, in which this rule, which used to be custom, is expressly written down and put down in writing to make it clear that the parties believe in it. And so it could happen that the rule that's found in the treaty indeed clarifies the fact that it's considered compulsory. But we have to be very careful understanding this interaction between treaties and custom, because treaties, due to their nature as an act of expression of the will of states, most of the time have a life separate from the process of customary international law. Treaties and, in fact, the clauses that the states agree on can actually also create custom by creating accords that deviate from the general rule of custom. But that's the whole point of looking at treaties as evidence of state practice. Treaties can be used to prove the fact that a certain rule is considered compulsory by finding the same clause in several treaties. They can be a proof that that practice is being modified by the fact that states are signing clauses that go against the understood customary rule. And they could, in fact, create a new rule separate from the existing customary rule by repetition. So, generally speaking, treaties are an important part of understanding what the rules of custom are, as they are expressions of the will of states in a clear manner, or they can actually be evidence of the fact that a particular rule of custom is no longer being respected. But always, 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 we have to give the proper weight to these findings from the treaties. The treaties will be evidence. They won't be a proof, so to speak, of the existence or non-existence of general rule, apart from the treaty obligation of the particular nature of this treaty obligation, but rather we use them as evidence of something else. It's a little bit funny because Article 38 gives the same weight to treaties, to general principles of law, to rules of custom, but in fact, there may be circumstances in which you are using a treaty to give elements to the existence of a norm of custom. But in that case, the treaty is being used just like that as evidence for the existence of a rule of custom, not properly as a separate source or a separate evidence of the existence of a norm. So having said that, and having known what elements can be used as proof of the state practice, we have to ascertain some other factors which are related to characteristics of the practice that the court has taken into consideration for determining the existence of a rule of customary international law. And the first one is the passage of time. Many authors argue against the instant creation of a rule of custom. There are considerations that there must exist some kind of practice for a rule of custom to arise. The great academic Joram Dinstein used to say that the only instant that he had at hand was instant coffee, and that was because he was in a rush to teach. And after that, arriving at school, he could not talk about instant custom because custom would require some sort of effort in the international community. A single act or a couple of facts by a single country or a couple of countries wouldn't be enough to create a custom, because the requirement to have a consistent practice requires time. Once again, we need feet treading through the trail and creating the trail by walking once and again. And it is said that at some moment, the roads that we have now were paths that were walked by animals, and eventually people started following them. And then eventually we created 12-lane highways over the places where a single rabbit used to run to get away from predators. And indeed, that's the way the roads are created. Well, here, the passage of time is important because to establish the existence of a rule of custom, we need the constant test on the way of practice to ascertain that this conduct is considered compulsory. We have to have a lot of cases to know that there is a rule there. And so the passage of time, it could be argued that maybe in a short period of time, we can have a lot of manifestations that could create custom. But even then, maybe 5 years, 10 years, there's no time limit. But there has to be some passage of time. And this is an important requirement. In the end, to show that there is practice, some time must have passed with the states following this practice to create a rule of custom. We have to make another qualification here as to the creation of the norms, which has to do with the generality of the rule. Rules of custom are intended to bind states whether they want it or not, because a rule of custom will be desirable for the whole community. That's like the basic tenet of custom. And that's the reason for which you could remove will as an element of the creation of custom, which we will discuss in a few moments. Most of the time, you would understand that international law depends a lot on the will of states, and the creation of norms, as exemplified, for example, in treaties, has to do a lot with states accepting the creation of the rule. But indeed, in this process of acceptance and maybe the expression of a sort of will of the state, states will sometimes be bound to rules that they do not find convenient for themselves. But in some sort of international reciprocity and in the desire for order, states will end up accepting these rules or following them, even if we would say in Spanish, a regañadientes, if regretting the fact that they're compelled to do that. But indeed, states will create and participate in the creation of rules that bind them even against their convenience. Let's not say against their will, but rather their convenience. And this characteristic of generality is one that we must study when trying to ascertain a rule of customary international law. To this effect, the International Court of Justice has talked about the idea of specially affected states, because indeed, in the practice, the rules that have to be followed as rules of custom will be created by the practice of states that are relevant to that practice. And in this way, even if the process of creating a rule of custom by practice is egalitarian, somehow we have to weight the importance of the practice of some states more than others to create the rule. And this is a merely factual, practical consideration. Why is that? Well, the classical example has to do, for example, with the rules of law of the sea. The process of creation of the rules of the law of the sea ended in a series of conventions. And in fact, there were nations that did not want to participate due to their being landlocked. And it would be interesting to know, if we get into the study of international law of the sea, what's the difference between a state that's landlocked and a state that has the biggest fleet in the world when qualifying their practice regarding the law of the sea? Because indeed, even a landlocked state might have an opinion about how things have to be done. But the fact is that specially affected states, the ones that have to live with the rules created by the international community, their opinion must be weighted and their practice must be weighted in a special way in which we see how that position that they hold in the international arena affects the concrete application of the rule. And once again, the North Sea continental shelf cases were an excellent example of this, because they hinged on the fact that we have two competing arguments, one related to a convention, which was not signed by one of the parties to the case, and the other to a method that was purported to be custom by the other states. So the fact is, we had two clashing interpretations as to what the rule of law should be in analyzing the delimitation of a continental shelf. And in fact, the analysis of the court went to see what were the practices that the states in the region were undertaking, and trying to find out if the methods that were proposed, the baselines and the equidistance method, which yielded very different results in the creation of the boundary lines around the continental shelf, had a basis in custom. And in that particular case, the court actually found out that the method that was being proposed did not have sustenance in custom, but it pointed out the fact that if you are to prove custom, it is very important to consider the specially affected states, which are the ones that in the end have to work with these rules. We would be very interested in finding out if this landlocked state has an opinion, for example, on sea lanes, but the fact is they will have an opinion, but the practice will not be as important. But maybe they actually own ships and extend flags to ships that have shipping lanes and that under treaties are shipping out of ports of other countries. And maybe in that case, if we have a landlocked state that has interests in maritime lanes and in maritime practice, maybe we are interested in their opinion. And that, once again, we analyze if their conditions affect the way that we have to make an interpretation of their position and their practice. This has come into play also in cases such as the advisory opinion regarding the use or threat of use of nuclear weapons. Because in the end, the practice has to be analyzed not only uh, related to the opinion of whether or not a rule operates, but the fact that there has to be a meaningful action behind the practice of states. And in that sense, we come to another element that has to be considered, which is uniformity and consistency of the practice. Uh, we need a series of facts that are intended to correspond to a general rule, but there has to be a uniformity of acts. Like all of these actions have to go to finding a pattern of conduct of states that is considered as compulsory. Not necessarily all the time, but the court in Nicaragua, in the Nicaragua case, gives a little leeway, and practice must be almost always consistent. Like not all the time, there may be deviations, but in fact, the practice has to have a sort of consistency. And if in fact deviations from the general practice are considered as deviations or as breaches, and if there is protest by the international community, and if there is some sort of repudiation of this attitude on behalf of the state that breaches the international order, indeed we have a reinforcement of the idea that we have a rule of custom. But so what is required of the international community is a consistent practice and more or less uniformity. We have to see that states, when facing a particular course of action, most of the time will react in the same way. If this reaction is consistent, if we have a uniformity of opinion as to whether the actions have to be this way, then we have more or less a uniform or consistent practice. So far, we have concentrated on the part of practice, which is most of the time material. It is built by the daily work of states, by the usual activities of the state, by their participation in international forums, in international organizations. But what we're looking is at the external attitudes of states. That leads us to what we call the subjective element or the psychological element of custom, which is called opinio juris. Opinio juris would quite simply mean the belief in the fact that something is legally compulsory. It is considered to be a subjective element, a belief, a psychological element, and well, it's a little bit funny to think in terms of having a psychological element. In the end, how are we to ascertain the belief, the thought of a state? I mean, states do not have an intelligible way of expressing their feelings. But indeed, the language that the court has used and the experts in the International Law Commission and many academics leads to these words, which seem a little bit funny in the context of international law, in which we're looking actually about this nebulous area of feelings, of understandings, of beliefs, as we had an article of faith in international law. But what does it mean in practice, and what are we expected as international lawyers to look for when trying to ascertain opinio juris? Well, we return to the North Sea continental shelf cases, in which we can read that two conditions must be fulfilled. Not only must the acts concerned amount to a settled practice, but they, and this is the second part, they must also be such or be carried out in such a way as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. So this is the fun part. We already have an expression of the practice of states. We have states doing things. They write memos. They send each other diplomatic cables. They go to international fora and they state their position. Sometimes they order things within their countries that affect foreign nationals or foreign states. We have several ways in which states are actually showing off the position that they hold. But is this practice actually practical consideration, problem solving, or is it ascribed to the belief of the existence of a rule? Well, that's the whole point of the matter. To find out a rule of custom, we must not only have the practice, but we have to have some evidence that there is a belief that the practice is a manifestation of a rule of law. I always like to bring up this weird example from nature, which is that some migratory birds have paths that are not straight at all. So some birds, when migrating south in the winter, for example, will suddenly go in a straight line and at some moment make a round trajectory over a valley, for example, and then continue straight. And it's a very weird phenomenon that ornithologists study. And the working theory around this is the fact that at some moment in history, there was an obstacle in the path of the birds. Maybe there was a forest, maybe there was a mountain or a volcano or something like that. And the millenary life of the world has modified that terrain, but the path of the birds still considers that there is something in their path. And so maybe without even knowing, they avoid this invisible obstacle because they consider the obstacle to still be there. Well, the opinion juris aspect of international law is a lot like this. States avoid an invisible wall because they consider that wall to be present and to be respected. And the expression of their practice, the path that they follow, might be an evidence of the belief that there is a wall on their way, so to speak. Opinion juris is a little bit complicated to show most of the time, because funny enough, the way to show it has to do a lot with the practice of the states. Like, this is funny. We have apparently two separate things that we have to prove with the same set of elements. But in fact, opinion juris is an expression of this compulsory part, and it can be ascertained by actions other than the practical application or resolution of a situation. Practice must never be divested from the belief of this obligatory nature of the existence of a rule. Otherwise, it's empty. Like in the Lotus case, the Permanent Court of International Justice gave us some examples of actions in which states, for example, in the high seas, practice consistently, for example, flag salutes or some administrative things that happen among ships. But in fact, if you were to show how they operated in the terms of international law, there was no consequence to not carrying out this practice. And the practice devoid of consequence had no consequence, so to speak, or no reaction from states. So we had practice, but we didn't have that compelling element of opinion juris to show off the fact that we consider this to be legally obligatory. So it's funny to see that we have these elements of practice and belief, and they have to be ascertained in this very artisan feeling to understand whether we have a rule of law. And it's very funny that the word feeling is brought up once and again when talking about custom, because we do not have a real way of knowing the feelings of a state. I mean, we cannot ask a state, how are you feeling? What do you need? What do you want? But in fact, we have to study the practice and try to work out something from that. Here is a distinction I think that can be made to understand this in a more practical way. In particular acts of state, like the administrative, legislative, judicial acts of the state, represent a practice. And this practice is individual. That's the state practice, the practice of a single state. And we have the practice of several states, then we have a pattern. And then we have a pattern that corresponds to what we understand as state practice. Sometimes you find the name inveterata consuetudo. That's a very old continuous practice. But the pattern that is ascertained as a state practice is individual. It's a single state, and then we have to study all of the states that are doing the same thing. That's state practice. But on the other side, we have opinio juris. And opinio juris is not directed as understanding to the particular position of the state. State practice is what I do in following a rule, what I think is a rule. But I mean, there can be practice devoid of this belief of the existence of a rule. So what thing is a practice? Like the material thing. But the part of the opinio juris has to do with the state's position on whether there is a rule, and more specifically, a rule that should apply to the international community regarding what I practice at home. If I think that this norm is compelling and I practice it, we have practice. But if I feel that this rule is compelling and is obligatory because not only me, but all the states should follow it, then what I'm giving is evidence of the existence of opinio juris. And sometimes it can be an outright statement as saying, yes, I believe that there is a rule of law and that my attitude corresponds to law and that this legal rule compels me to do this. So in fact, some actions of the state can be shown to be evidence of practice that reflects belief, and it's very fun. The fact is, when ascertaining a rule of customary international law, you can use some elements either to prove opinio juris or state practice, but most of the time, if you're using it to prove one, you shouldn't use it to prove the other. Either you're showing a pattern of actions by a state that constitutes state practice, by a state or states, or you are showing their belief on the compulsory nature of those actions, in which case we're talking about opinio juris. It's sometimes a little bit confusing, and the court does not adhere to the formula all of the time. And sometimes they pick and choose by convenience, and sometimes the same action can be used as evidence of either practice or opinio juris. But in fact, there is a very slight difference, and we have to be very careful when studying patterns of purported customary rules to see if what we have is a state practice or opinio juris. But going further, we can refer to the advisory opinion regarding legality of the threat or use of nuclear weapons, in which we have a very firm foothold on the ways in which we assert an opinio juris. The court referred to a very specific case, and this is very interesting as a staple of how opinio juris is asserted. General Assembly resolutions. Most of the time, we are told that the documents of the UN are not legally binding, which makes sense. Resolution of the General Assembly is a position. It's an opinion. by the General Assembly, stating we have a problem and it should be solved this way. And you can contrast it to the executive way in which the Security Council of the United Nations solves problems, in which, well, the Security Council resolutions order, invite, command, create organs, create missions. Well, the General Assembly observes, it's worried about, it's suggesting, it's inviting. So General Assembly resolutions are not legal documents or did not create these obligations by itself, but in the matter of customary international law, they're very interesting as expressions of the opinion juris of the states. Because indeed, in the General Assembly resolutions, most of the time, due to its generality and the way that the United Nations works, we have sometimes clear expressions of the beliefs of states. The General Assembly concerned with this problem, recognizing the principle of X, Y, and Z, and the resolution points it out. We recognize this principle. We consider that this principle has a place in international law. And so the way that these resolutions of the United Nations, even if prima facie they are not legally binding documents, they do not create obligations by themselves, they can show the belief of the international community in the existence of a rule of law. And in my point of view, this is amazing. We have the states actually agreeing on stating some rules and the building blocks for a more complex legal system. Indeed, the legality of threat or use of nuclear weapons advisory opinion refers to several resolutions, including the resolutions on friendly relations, which state a series of principles which the states, by consensus, consider to be the basis of international relations. So, funny enough, this non-legally binding document is actually an element for the understanding or for the determination of the existence of a rule of custom. And in the same sense, you have to know how to work with these kind of things when approaching Jessup, because this is one of the most common things that you will be asked to talk about, the value of a General Assembly resolution. You will hear that question at some moment if you are in Jessup. Why? Because the use of these documents and the use of the principles contained within are one of the most important building blocks of international law. But as with all your evidence related to sources of international law, you have to know where to use it and you have to understand why or how you're using it. So we have two situations here. Either we have a resolution which clearly states that we have a rule of international law, of customary international law, or we have a series of resolutions in which we can see a pattern in which states are dancing around an invisible wall, which leads us to believe that there indeed is a rule of customary international law as recognized by the practice of the states and by their affirmations. So we have here the example, the particular example of General Assembly resolutions, but this analysis extends to other documents produced by states in their international engagements. And as a way of example, and being a non-restrictive list, we have well, the General Assembly resolutions, but also the resolutions of other organs, of other international organs or organizations. Because indeed, international organizations can state their belief that there is a particular rule. It might happen. We have the International Law Commission and the documents that they produce, and it's very fun to see that the International Law Commission is actually a group of experts which are tasked to codify and to progressively develop international law. But a lot of times they act, and Mr. Alain Pelé calls them the little sister of the International Court of Justice, which I find a beautiful image. The International Law Commission indeed does a lot of things that the court finds cute and sometimes compelling, and that are very often used to a certain some circumstances of their interpretation of law. So, in fact, the International Law Commission had just presented one of their first readings of the articles on international responsibility, and a couple of months later, the document was still fresh from the oven. And in the Nicaragua case, the court goes and uses that document from the International Law Commission and starts using it as the basis for analysis of the case. So the International Law Commission actually does a lot of work on codification and on the determination of some rules to be custom, and they do the work, the academic work and the theoretical work, but they also do this progressive interpretation as to what is desired of international law. So the documents by the International Law Commission can be used as building blocks to find the pattern of opinio juris, but, and this is a practical recommendation for Jessup participants, if you are using a document by the ILC, you have to know whether it's being executed as codification or as progressive development. Because if it's being done as part of codification or study, then you have elements to use them as proof of opinio juris or the elements of the existence of the rule. But if it's progressive development, well, it's good hopes and a prayer that this should be the thing that states eventually will accept. So we could find elements of opinio juris in the ILC and their work in codification and recognition of customary rules. We can also find a pattern of opinio juris if we analyze codification from other sources rather than the ILC. We have regional legal consultation organs, for example, in the Organización de Estados Americanos, which also undertake projects of investigation as to rules of international law. And sometimes they may give elements as to the existence of a rule of custom and might represent opinio juris of regional groups. But also we have a very hard evidence, sometimes in treaties, of the belief in the existence of certain rules. And this is a bit of the process that we call crystallization, when states state, so to speak, a rule of international law and put it down in writing. So we have the certainty that they consider A, that there is a rule, a general rule, independent from the treaty, and B, they want it to be as clear as possible. So as it becomes compelling and obligatory between the parties that are signing the treaty. But in fact, this element of finding rules or special clauses or something within the treaties might show that states do consider that it's their obligation and that there is actually a rule of law. So these kinds of documents, once again, are evidence. We are talking about custom as this huge box, but it's a box full of a lot of trinkets. And out of all those trinkets, we have to ascertain whether they correspond to a norm, to this rule of custom, or whether they're only practice, or maybe they're only opinio juris. Because in the end, you have to have both. You can have the state practice without the belief that the practice is compulsory, and you cannot have the belief that there is a rule of law without the relevant practice. And once again, the court has been able to study examples of this, both of a rule that has no practice, no meaningful practice, a purported rule, and of the practice that has no compulsory nature. So we have to have the two elements, and we have to have a very strict analysis of the existence of both elements so that we actually know that we have a rule of customary international law. Otherwise, we do not. Like the classical example is with the nuclear weapons. There is purportedly a rule which would be that the use of nuclear weapons is illegal, and we contrapose it to rule of nuclear deterrence as a customary rule. But the thing is, the states that can actually practice, the especially affected states, are those that have nuclear weapons. They're the ones who can have a meaningful practice regarding to the use of the nuclear weapons or the decision not to use them. And so there are a bunch of states which say, well, the rule should be that there should be no legal use of nuclear weapons. But the states that believe that have the opinion juries, have no nuclear weapons to back up their practice. And the court pretty much said, well, nice as it could be, the only thing we have is the fact that the practice of the nuclear states, the fact that there is a practice by the nuclear states, is avoiding the creation of a rule based on the opinion duties of the non-nuclear states. It's paradoxical, but in the end, we have the two elements split into sides, and the fact that we don't join them and we don't have a consistent practice and an opinion duties avoids the creation of a norm. Which in fact leads us to the next topic, which is the topic of consent. We are talking about rules that are created by practice and that are meant to be general in nature. But in the end, the creation of the norms of customary international law has to do a lot with the willingness of states to accept them. It's a little bit of acquiescence and a little bit of active will. But in fact, the fact that the rules of custom sometimes go against the individual interests of states and more to the general interests of the community makes it weird to talk about consent in this context. Because we could argue that states have a chance to object to the creation of a norm. And we refer to the idea of a persistent objector as a way to split yourself from the application of the rule. But here's the thing, and this, once again, one of those practical considerations that the theory from the practice. If you're defending a case which hinges on a rule of customary international law, which do you think has the lower threshold for convincing a judge or a judicial organ? The fact that your objection is an obstacle to the creation of the rule, or the fact that you're rejecting the creation of the rule means that even if it exists, you are not bound by it. That's like two different thresholds for the same argument. But the fact is that the consent of states to be bound by the rules is somehow a consequence of their practice and their representation of the opinion duties. But in the end, a rule of law that is meant to be a rule of custom will be applied whether you consent to it or not. Like, it's a consequence of the practice of the whole international community. And it's a consequence of the belief that there is a compelling rule of law that applies to the whole community. But it's like kind of paradoxical, right? States have to object to the creation of norm at some moment. But then if the objection or the not following the practice or the showing against the creation of the norm is intense enough, then there is no rule of custom. Like, if you actually not participate actively or have practice against, you might be resisting the creation of a norm. And there are many examples in international law about this. For example, there are a lot of examples of states being unwilling to accept the exclusive economic zone at some moment of history, or having the 3-mile limit for the limitation, or 12-mile limit. And these criteria that are different, they result in the fact that we don't have a consistent practice. And so the rule doesn't come into being until states agree on certain particular aspects, and that minimum, which is agreed, becomes a rule by the way of practice, by the way of the belief that's the bare minimum that we agree on, and it becomes a rule. But in fact, the objection at some moment in the creation, and I mean, these are things that are pretty much magic and philosophical and hard to ascertain. But the fact that a state participates in international law in the process of creation of the rule means that it intends to follow it, and that it intends to consider it compulsory legally. But no participation and objection and non-acquiescence to the processes of practice regarding the particular thing can actually consider a state as rejecting the creation of the norm. But if the norm actually comes to be, some states take the position that they can object successively to acts or to several applications of practice of a particular rule, and thus be exempt from the rule. But once again, this is like a very complicated threshold to navigate. We have the luck as lawyers to be able to argue in the alternative, and we can set a threshold for non-existence of the rule, and then go to an exception to application of the rule to ourselves, to our states represented. But in fact, as you can see, these effects of the creation of the norm in the general theory of custom, the rule of customary international law is intended actually to bind any state related, all states. Like this characteristic of generality lies at the core of what custom is. Objection, most of the time, will have the intention to avoid the creation of the norm. But indeed, if we follow the theory of the persistent objector, which has been affirmed by international tribunals, then there are circumstances in which this objection, persistent objection to the rule once existing, saying I am not bound by the rule, somehow avoids the rule actually binding the persistent objector. We have an exception, which would be the one found in what we call jus cogens. And here is a thorny which is, I mean, one of the that international law finds mystifying and fun, which is jus cogens. We're talking about customs, so we have to make a mention of jus cogens. And jus cogens, if we are to go to the Vienna Convention of the Law of Treaties, which is the most famous instrument that mentions it, is this peremptory norm of general international law, this special category of norm that cannot be derogated by any rule except a successive rule of the same category of the same character. And sometimes jus cogens is very misleading. When we're arguing about jus cogens, we're talking about a rule which is so compelling and so enmeshed in the core of what international law is, that there is no derogation from the general rule. And if we just do a cursory reading of what jus cogens is, we can be led to think that it's some sort of super custom. Like, it's this rule of custom that cannot be stopped by other rules of custom or by anything whatsoever. But let's split this discussion about jus cogens in small bite-sized morsels. And let's start with the fact that it's mentioned in the Vienna Convention on the Law of Treaties. And why is that? Because jus cogens indeed is a sort of international morality of public order consideration, in which there are rules which are the structure of the international system, which would admit no derogation. Back when the Vienna Convention was drafted, there was controversy as to the jus cogens category, and there are commentaries on the draft that say that it is a useful category, even if we don't still know what it comprises. But in fact, jus cogens is a label for a type of norm. And here's where we have to be very clear. Jus cogens norms are not only customary rules. They can come from a lot of places. And if you're interested in studying a little bit more related to jus cogens, the International Law Commission actually has a working group, which are, they handed out a report recently related to jus cogens. And amongst the determinations, we know that jus cogens norms can be treaty-based, can be customary, most of the time are customary. They can come from general principles of international law, but it's a label. Like jus cogens refers to a specific kind of obligation. It doesn't actually matter whether they're custom or not. But many times we will turn to jus cogens in the context of the discussion of custom. So just to be very clear, jus cogens norms can be custom, but they're not always custom. And in fact, they respond to a pattern that was originally thought of as a little bit closer to natural law, of the fact that we have these constitutional rules of the international order that are so compelling and so important that they cannot be derogated. They correspond more to a system similar to the norm creation in custom, but we have to be very clear on the fact that jus cogens is a category of norms and not a part of custom formally or a customary rule. If we thought of jus cogens rules as customary rules, we would be thinking of a super custom. And indeed, some scholars have discussed that in that light. Very famously, Professor Anthony D'Amato had an article called "It's a Bird, It's a Plane, It's Jus Cogens," and he talked about jus cogens as a super custom, superior to any other custom. But in fact, like modern studies tend to identify it as a category of norms within international law that can come from a lot of places, which are labeled as to their importance and to the fact that they're the bedrock of international law. So just a addenda at the end. When do jus cogens rules come up in the Vienna Convention on the Law of Treaties? Well, most of the time when you draft a contract, especially in Romantic, Germanic, canonic traditions, civil contracts have a restriction to actually contract against public order and some rules of public decency and community standards. That's pretty much jus cogens in international law. And that's the reason that the Vienna Convention on the Law of Treaties brings up jus cogens. Because in fact, these super norms that are constitutional in nature, that are the backbone of international law, could not be derogated even if we wanted. And in fact, that's what leads us to differentiation of this level of jus cogens and the idea of custom. Custom can be modified at any time. Subsequent practice can modify what we consider a rule of custom. Even the rule may exist and may be stated and may be understood, but future practice can modify the way that the rule is understood. And in fact, a rule of law can lose its character of custom by the lack of practice from states, which is a process that's called desuetudo. The lack of the practice regarding a certain norm of custom can result in the death of the rule. It just simply disappears because we're not using it. We may find it legally compelling, but if suddenly states stop practicing it, well, the norm dies. And that's a very important difference with jus cogens. Jus cogens is understood to be, it is, just like that, an article of faith. And nothing we do can derogate from that. And well, in fact, it's just a handful of rules. The ILC identified no more than 10 rules that it considers to be jus cogens. And they cannot be modified by the usual pathways of custom. They can be customary in nature, because in fact, there are rules that may come out of practice. But once these rules magically, alchemically acquire the characteristics of jus cogens, they indeed become rules of such importance that the only way to derogate them, the only way to modify them, cannot be through a treaty or through subsequent customs or anything like that, but actually through the emergence of a new rule of jus cogens. And so we have a general perspective of what custom implies, of what are the elements of custom and how it works. And as such, and if there are no further topics to be discussed, I'd like to thank you for your attention. And I'd like to thank you for the opportunity of sharing this with all of you. It's a great experience being in the Jessup. I invite you to enjoy every last crazy, maddening moment. Enjoy your memorial process. Enjoy your oral rounds process. It goes by so fast. Make friends, talk with people from all over the world. Well, let's keep doing this. I'm very happy to be here. I'm very grateful to Claudia and to the rest of the organization. And I hope that all of this was of some use. So thanks.